Welcome to lecture number 11. This week we're discussing the trial process. If you remember from previous lessons that 90% of criminal cases are processed through a guilty plea. So only about 10% of cases processed in the criminal courts actually result in a trial of any sort. Of these trials, about half are bench trials. A bench trial is where the judge listens to the evidence and determines guilt. And there's no jury in the process. And then the other half are jury trials, where there's a group of people from the community, a jury of your peers, that listen to the evidence and determine whether or not the defendant is guilty. So a jury trial, even though that's the norm of what you see on TV dramas and things like that, a jury trial is actually a very rare event in the American criminal justice system. Only about 5% of all criminal cases actually result in a criminal trial in front of a jury. In the spirit of democracy, members of juries in the United States are just common people. When we were under English rule before we were a nation, in order to serve on a jury, you had to be wealthy and a landowner. So if you've got, a destitute poor person who's being charged in a crime against a wealthy person who's in power, of course you're going to expect that a jury full of also wealthy, powerful people and friends of the victim, are more likely to find the defendant guilty. So when we established our country in 1776 and we eventually developed our U.S. Constitution, we wanted to make sure that everyone was treated equally and that everyone in the United States has an equal chance of being on a jury in criminal cases. So in most states, people are randomly selected for jury duty from a list of all persons with a state driver's license or a state identification card, because we don't want to exclude people who are poor and can't own a vehicle. So we also include the ID cards. There are no educational requirements for this. Whenever there's a jury finding that shocks the public or makes a certain group angry, there's always people on talk radio or television news interview shows where they're saying, gosh, we ought to have requirements for an education and things like that. Well, that's not fair. That's not part of the American system. And sure, you would like that if that makeup of the jury will result in your favor, but how about the next person? They might want somebody who's uneducated would be more likely to side in their favor. So we don't have any property requirements, any educational requirements. Males, females, doesn't matter your race. In some states, it doesn't matter if you're a U.S. citizen or not. If you have a state ID card or a driver's license, you could be called on jury duty. When a jury trial is going to happen, the juries are selected from a group of potential jurors. So they bring in a group of anywhere from 30, 40 to sometimes if big trials that are getting a lot of media attention, they may bring in 200-300 people as potential jurors. These potential jurors are questioned by the defense and the prosecution in a process called voir dire. Now, the purpose of these questions are to determine if the juror has any potential biases that may influence their decision in the case. So each side can remove an unlimited number of potential jurors by demonstrating to the judge that the juror would be biased for or against the defendant. This process is called a challenge for cause. So say, for instance, if the defendant is African American and one of the jurors that you're questioning as the defense attorney ends up making a very bad racial statement that shows that they're very biased against African Americans, then you could say, Your Honor, I'd like to remove juror number 34, challenge for cause, and usually they don't even have to explain it. The judge saw what happened, and the judge will happily remove that person from the jury pool. Each side may also remove a limited number of potential jurors, and that's determined by each state's individual state law. It's usually only 2 or 3 jurors can be removed this way without without having to state what the cause is. And this is called a peremptory challenge. So you just, as a defense attorney, you may not like the way that a certain prospective juror has just been looking angrily at your client, or they seem to be not paying attention to what's going on, or they seem to be rolling their eyes a lot, it might be hard to convince the judge that that's a reason to remove them from the jury, but you have the option of 2 or 3, depending on your state law, options to peremptory challenge and remove jurors that are behaving in that way. So this process continues until a final jury is organized, and usually a couple of alternate jurors are also added in case something happens to the people on the regular jury, if somebody gets sick or if they get kicked off for some sort of improper behavior. Then you go into the trial process. The jury decides whether there was sufficient evidence to find the defendant guilty of specific charges of which they're given. You can't bring them in and, the only charge that they're looking at is attempted murder. The jury can't say, well, we don't think he was guilty of attempted murder, but we'll find him guilty of aggravated battery instead. Not unless the prosecutor also gave them an option to consider the aggravated battery. They can only consider the attempted murder charge if that's the only charge that's presented to them. So they're looking at the specific charge and the specific description of that charge defined in the statute, and then they need to determine if the evidence they heard during the trial was enough to convince them 90% sure that the person, again, that's not 99% sure or 100% sure, it's 90% sure that the defendant actually committed the crime that they're being charged with. Note, they do not find defendants innocent. You can't say, well, I went to trial, but they found me innocent. They don't do that. The system is very open about the fact that every day there's trials, places where the defendant is guilty, but we couldn't find the defendant guilty because there wasn't enough evidence presented at trial to support those specific charges. So be very clear about that. The jury is only considering the charges that they've been presented with, and they can only determine if the evidence that was presented to them was sufficient to make them 90% sure the defendant was guilty of these charges. So they were either guilty or not guilty based on the evidence that was presented at trial. So, attorneys, both the prosecutor and defense attorney, want to usually know what factors influence juror decisions. So there's been a lot of research. Most of it has not been in criminal justice. Most of it's been in the field of psychology into what factors influence juror decisions. That's going to be one of your readings, is a review of all this literature that already exists in psychology research on juror decision making. But as you read these, note that the majority of these studies, especially because they came from the psychology, are using just freshman college students and putting them in mock jury trials. They're not actually handling a real criminal case. They're not actually members of juries, and they're usually all people seeking college education between the ages of 18 and 22. That's not the typical makeup of your typical jury. So for any of you interested in this type of research, there's a huge market for it. Attorneys are willing to pay top dollar to get this type of information, and it would be more useful if the future research and more research actually occurs with real members of real criminal juries. Then, in all but a few rare exceptions, the jury doesn't determine the sentence. It's the judge that determines the sentence. So if it's a jury trial, the jury determines guilt or not guilty, and the judge determines what the sentence is going to be if they're found guilty. In a bench trial, the judge determines if they're guilty or not guilty, and then the judge also determines what the sentence will be if they're found guilty. So this week we only have 2 readings, mainly because this first reading is so long. It's Jury Decision Making, 45 Years of Empirical Research on Deliberating Groups. So this is an overview and a review of all the known psychology research up to the year 2001. And Dennis Devine, psychologist from Indiana University, Purdue University at Indianapolis, is the leader of the team of researchers that dug through all these studies to provide this information for prosecutors and defense attorneys. Again, this is an area that is very needed for more research, especially research with actual juries, studying actual juries, which is hard to do. It's hard to get permission to do this sort of thing. But for any of you looking ahead at a career as a researcher, this is definitely something you need to think about as a possibility. And then, let's assume that the person was found guilty. The next stage is sentencing. So the next reading is Sentencing in Context, a Multi-Level Analysis by Jeffrey Elmer from Penn State and Brian Johnson from University of Maryland. They look at sentencing data after bench trials and jury trials for many year time period all across Pennsylvania, and find out what is correlated with the severity of the sentence. So is it the defendant's characteristics? Is it the amount of evidence in the trial? Things like that. What influences how hard the judge wallops the defendant when they're found guilty. And as usual, don't forget Quiz 11 at the end of the week, and email me if you have questions or concerns.